Good afternoon, everybody. Sorry for the delayed start to the seminar this afternoon. For those of you that don't know me, I'm Fay Collinson, a barrister here at King's Chambers, based in Leeds, Manchester and Birmingham. And today I'm going to be speaking to you about capacity to execute a lasting power of attorney, an update from the High Court. Before I get stuck in, if you're not aware of me, I know that many of you are from having looked at the attendance list. I have a practice that crosses three different practice areas: wills, trust and probate, contentious and non-contentious property, and court of protection work, but certainly exclusively within the property and affairs domain. And I obviously practice as a barrister, but also as a mediator as well. I say this every time. I'm always contactable by email. I try to come back to everybody about any questions they have on the seminar. It's quite difficult to deal with them as the seminar is going through, but I will try and keep my eye on the chat function. That's my email address and also my clerk, Vase. So if you do have any questions about the seminar or any other matters, then do feel free to get in touch. So on to the stuff that you're all actually interested in. So I'm going to be talking about a decision, a recent decision from the High Court, and it's the case of Public Guardian and RI and others. It's a decision of my former head of chambers, Mr. Justice Paul, sitting at the Court of Protection in Newcastle. And as will hopefully become clear during the course of the next half an hour or so, this is the first, certainly persuasive decision that gives clarity to the test to be applied when we are considering the question of somebody's capacity to execute a lasting power of attorney. So this applies to lasting powers of attorneys, both in the context of property and affairs, but also health and welfare. Of course, when you're dealing with a health and welfare lasting power of attorney, there will be different considerations specific to that power that need to be considered. But broadly, the test applies to both lasting power of attorneys. So if some of you need a quick refresh of the relevant statutory powers, everything is set out within the Mental Capacity Act. And also the accompanying regulations, the lasting power of attorney, enduring power of attorney and public guardian regulations 2007. That should have at the end of it amended, because they've been amended a number of times. It's always worth refreshing your memory of those regulations, because there are a couple of things that concern sort of the discharge of the security bond and the particular steps that need to be carried out in order to execute a lasting power of attorney. One thing I'm particularly thinking of is the order in which the individuals have to sign the lasting power of attorney. So it's a good bit of knowledge to have in your armour. But when we're looking at cases within the Court of Protection, the usual issue is whether an individual had the capacity to execute the LPA. And I'm sure many of you will have been involved in contentious property and affairs application where the task was seized with making that determination. And Section 22 empowers the Court of Protection to make various determinations about lasting power of attorneys, particularly with regard to whether the qualifying criteria is met out. One thing to remember is it's not just capacity that the COP has the power to decide. It's also undue influence / duress as well. That's less common, admittedly, but I have had a couple of cases where that's been considered. So do remember that even if you have a case where there may be capacity made out, there may still be instances of undue influence or duress. And another section I wanted to draw your attention to is Section 14 of the Act, which concerns the protection of an attorney. So it may well transpire that you have a client where the ultimate decision of the court is that he or the donor lacked capacity to make the lasting power of attorney. You then may have a client say, well, I'm very concerned about the conduct or the actions I have carried out in purported reliance on that lasting power of attorney? Am I now going to be accused of a breach of fiduciary duty, for example? But as long as the client didn't know that the individual lacked capacity, or there weren't circumstances that made the attorney believe that the donor now retained capacity and so could manage their finances themselves, then they have certain protection afforded under Section 14. So just to start with the facts of the case of RI. So it concerned an individual, a male, who was in his 60s, and he suffered from quite a severe learning disability, and he also suffered from schizophrenia. The evidence was that he had, for almost all of his life, lived with his mother at the family home. However, she became unwell in 2014, later dying in 2015. And in consequence of that, P had to move to a residential placement. When he moved to that placement, he was ultimately subject to a standard authorization, otherwise known as a DOLS. The issue in this case concerned a P&A lasting power of attorney that was executed in 2009, so a few years before P moved into the care home. And under that lasting power of attorney, he appointed his brothers and his mother as his joint and several attorneys. The certificate provider was reported to be an executive in a legal firm. I have provided that in quotations because it's not clear to me from the judgment whether that individual was a Silex or whether they were an executive without any legal qualifications. So as I say, that was unclear to me from the judgment. But there is reference within the judgment to that individual at the time being employed by a firm of solicitors, which by the time this case came before Mr. Justice Paul was no longer in existence. And JH, the executive, could not be traced, so there was no evidence from him. The genesis of the application was a complaint made by the care home in which P resided. The care home manager had, it seems, certain concerns about financial misappropriation or financial abuse. And it seems the trigger for that was a apparent refusal to pay for a holiday to Blackpool. And so the care home manager felt that the attorneys weren't acting in P's best interest. Not only that, it appeared to be the case that the attorneys had delegated management of P's estate to his sister-in-law. That triggered investigation by the OPG, and in consequence and as a result of that investigation, the OPG questioned P's capacity to execute the LPA because of his learning disability and chronic schizophrenia. As often happens, and many of you will have seen these reports within your own cases, P was assessed firstly by a court visitor. The court visitor concluded that P at the time, so contemporaneously, lacked capacity to manage his funds and to revoke the LPA. The court visitor also went on to give a view that P lacked the capacity to execute the LPA, but the OPG relied upon a report from a special visitor, so a qualified doctor, in pursuance of its application. And the outcome of that individual's report was, again, that P lacked capacity to revoke the LPA, manage his finances, and create a new lasting power of attorney. And he went further after questions by the OPG to conclude that P lacked the capacity to execute the LPA in 2009. And of course, that report was based on an assessment that was carried out in around about 2019, when I think the complaint was first made. So that was a retrospective assessment, which appeared to be based primarily on GP notes. For the purposes of the application, it was not in dispute that P, at the time of the application, now lacked the capacity to revoke the LPA and execute a new one. Where the divergence in view was between the OPG and the family, who I think were unrepresented in the application, was this. The family said, well, our brother has experienced a quite substantial decline in his, quote, behaviours as a result of his move to the care home. Having lived with his mother all his life, it was said that he found that, as one might expect, to be an incredibly traumatic move. And as many of us have seen in our own practices, that can lead to quite a significant step down in an individual's mental health, with consequent effects on their cognition. And that was what the family were asserting within this application. They were saying, even though our brother is presenting in this way now, and it was reported that at the time of the LPA, he was able to manage bits of his own money, he was able to understand what an attorney was, he was relatively independent and would go out and have his own day trips. By contrast, by the time the application comes before the court, he was subject to deprivation of liberty safeguards. He wasn't able to go out into the community unless he were with somebody. It seemed he had committed some criminal acts as well, albeit relatively low level. And so the family said that you cannot judge how he's presenting now as how he was presenting in 2019. So it seemed to me one of the sort of key issues of fact was to what extent, if any, there had been a deterioration between 2009 and 2019, and was the expert's evidence in the report in 2019 reflective of P's capacity in 2009. One of the key things you can take from this case, and this applies to those of you who are dealing with contentious COP work or uncontentious COP work, is what the relevant information is that a donor must understand. So when your client is coming in to you to say that they want an LPA executed, and they're probably going to be doing that at the same time as maybe executing a will, you need to understand, in the same way that you have with Banks and Goodfellow, the series of information that the donor has to be able to understand. Not that they can necessarily demonstrate an understanding in that given time, but that you are satisfied they are able to understand that information. One useful starting point is the OPG guidance, although I think on reflection, it's probably, in my view, a little bit superficial, I think. So I personally wouldn't rely on this solely. But the OPG says that these are the various factors that a donor must be able to understand. So what an LPA is, why they want to make it, who they are appointing as attorney, why they have chosen that person or people, and what powers are being given to that attorney. So what was Mr. Justice Paul's conclusions on the relevant information? Well, here you have it. And of course, I will send around the slides after the seminar, so feel free to copy and paste it into your own notes if you wish to use it. But I would encourage you, of course, to go and read the judgment for yourself. It's not particularly long. Mr. Justice Paul said that these are the various things or facets that a donor must be able to understand in order to have the capacity to execute a lasting power of attorney. So the effect of the lasting power of attorney. So what it is, what the attorneys are able to do as a result of that LPA, who the attorneys are. So these are relatively basic, unsophisticated decision making. Then it starts to get a little bit more complex. So the donor has to understand the scope of the attorney's powers, but also they have to understand that the Mental Capacity Act restricts the exercise of their powers. I've always thought that's actually requires quite a sophisticated level of understanding. I personally think that is analogous to the level of understanding that's required for a will, because they would have to understand that the decision making is subject to the best interest tests within the Mental Capacity Act. And so that follows that the donor has to have an ability to understand the Mental Capacity Act. And then it follows to this, which is when the attorneys can exercise those powers, including the need for the LPA to be executed before it is effective. I've put in brackets executed because I think what the judge actually probably meant, or this is my view, I may be completely wrong about this, was actually that it had to be registered before it was effective, which of course contrasts with the old style EPAs, because execution, I think, comes within the first limb, which is the effect of the LPA, and that you need to sign it in order for it to be executed. But of course, our LPAs have to be registered before that they can be used, and that goes to both LPAs. So the donor must be able to understand that even though they have executed it then and there, that there needs to be this additional step of registering it. And they also need to understand when the attorneys can exercise those powers. So that then is fact specific. Has the attorney limited their LPA to circumstances where they lose capacity? Because of course, Property and Affairs LPA can cover both scenarios. So you will have to have a discussion with your clients, as I'm sure you do, about when they want it to come into effect. And they have to be able to understand that if they aren't allowing the attorney to use the power until they've lost capacity, the consequences that might have. So, for example, delay in getting it registered, delay in getting capacity reports, what impact that might have on somebody's finances in the interim, because of course then no one can access the bank accounts. So all these kind of nuggets I think need to be explored. The scope of the assets that the attorneys can deal with under the LPA, and of course how difficult that is to understand is led, I think, by the scope of the individual's estate. You might have someone who just has a house and will just need realistically sale of that property and also payment of care home fees. By contrast, you might have somebody whose assets are held within various complicated trust arrangements, and what impact that's going to have on an attorney. So the ability to understand that aspect is, I think, dictated by the scope or complexity of the assets of the donor, in a very similar way to the Bankson Goodfellow test. The next aspect is the power of the donor to revoke the LPA when he or she has the capacity to do so. So the donor needs to understand, well, if I don't want this LPA to be in place anymore, what is open to me to do and what steps will I need to take, and that power is open to them. But also to understand if they lose capacity, what things might they need to do or someone do on their behalf in order to revoke the lasting power of attorney. So there needs to be an understanding, I think, particularly with elderly individuals and vulnerable individuals, about financial safeguarding. And this crops up a lot with the capacity cases, because usually the genesis of a complaint, I find, is a complaint made by arguably a disgruntled sibling, where an LPA has been granted to one sibling and they feel that they are left out of the loop a little bit. So they make the complaint, and then follows various allegations of financial abuse and financial misappropriation. And so you would have to address with the donor, well, what happens if somebody misuses your funds and things of that nature. They also need to understand the pros and cons of executing the particular LPA and of not doing so. So in health and welfare, what limited powers people will have to make decisions on their behalf. And if there is no LPA, how are their finances going to be managed? And what are the risks of not doing an LPA, but also the risks of doing an LPA? And that goes back to the potential risk for misappropriation. So it all sounds like it's academic and a test, and it is to that extent. And sometimes people will say to me, well, it's all well and good saying that those are the things that we need to address with a client, but can it come across as maybe a bit too adversarial, and we're being a bit aggressive in testing them on these things? But of course, there's a way, as those of you will know from conducting attendances on donors all the time, of testing your client without them realizing they're being tested. So an example is when somebody is asking about who they want as their attorney, explore who else might be their attorney, what family members they might have, and would somebody else in the family expect to be an attorney, and why are they picking that person over that other person? Because it's very often the case where you do have individuals who lack capacity, who've been drawn to a solicitor to make an LPA, perhaps for pernicious reasons. They will usually say, well, this is my favourite daughter and I really trust her. And you don't necessarily get to understand why the other individuals are being excluded from selection. And if you take without challenge that the donor is picking that sibling, then you can potentially miss out on those red flags that might highlight to you that there is a potential issue over this. So in summary, on this point, those are the factors that you need to think about when you are exploring execution of an LPA, and also when you are in the contentious side of things, to be certainly your framework for your capacity evidence. In this particular case, the judge found himself with a real dearth of evidence. At the case, the OPG was represented by counsel, but as I say, the family were not represented. And in consequence of that, I think that the case, certainly from their perspective, probably wasn't as front-loaded as it might have been, because, of course, they didn't have the benefit of solicitors to assist them with that. So the judge asked at the outset whether he should be adjourning the matter in order to have further evidence. And the paucities in the evidence that the judge identified were as follows. First, the special visitor did not provide any updating evidence in response to the family's statements, which I find quite surprising, because I will always make provision, subject to a judge, of course, agreeing with me, that after provision of witness statements, that the expert revisits matters, because, of course, it's usually only the family members that can give factual evidence about the circumstances leading to the execution. And it's important the expert considers that when coming to a retrospective conclusion. Not only that, the executive could not be found, so the court didn't have the assistance of the certificate provider, which I think was ultimately one of the matters that was probably fatal to this claim. Third, the special visitor only had the GP records, which again I found surprising, because usually at the first directions hearing, so if, for example, the DRH fails and the judge goes on to consider directions for the case, it's really important to make sure that there are the appropriate third-party disclosure orders providing for all P's relevant notes. And it's usually not just going to be GP records, but here, for example, I would have expected to see care home records, for instance, any other hospital records, because if P had schizophrenia, he may well have been under the care of a consultant as well. So there may well have been other records that were relevant to it. Also, DWP assessments and things of that nature. The final point was that the judge had concern over the expertise and qualifications. And I have to say, I shared, when I read this, that concern, because the expert was an old age psychiatrist, which might be an expert you'd expect to see with a case of dementia, for example, or perhaps even if P's impairment were limited to schizophrenia. But with an individual who was suffering from learning disabilities, my view is that a psychiatrist is not the right expert to assess that. I would normally go for a neuropsychologist or sometimes a neuropsychiatrist. So it's a surprising choice, but I think the way it works with the OPG is you don't really get much choice with who can be appointed. And the special visitor wasn't called to give evidence, which again I found quite surprising, because usually in the cases that I have, particularly if it's a contentious one, then the expert will be there for cross-examination. And you can make real headway with some of them. And I felt this was one where there should have been oral evidence, because the special visitor, when he was asked to go back and think about retrospective capacity in 2009, said this, that the nature of learning disabilities is that you have developmental problems from birth, which persist through life. The deficits are static, and I would expect similar problems with understanding and memory that are evident then and now. I felt that was a pretty generic, broad brush conclusion to ascribe to P. Every P is an individual. They have their own characteristics, of course. And I think it's wrong to go into an assessment of capacity with a generic preconceived view, which it seems to me this expert probably did. So those are the types of issues that I would like to have explored with that expert had I been in that matter, but I wasn't. So the judge, I think, was hesitant about continuing the matter against those evidential deficiencies. But as in any litigation, the court has to consider proportionality. And this is where there is a real difference, I think, in civil litigation and court of protection litigation. And I bang on all the time in these seminars about you have to have, I think, to do the best for P and also act in your client's best interest, is to move away from the adversarial nature of litigation. So when I have my probate hat on, I approach a case very differently to how I do if I've got my COP hat on, although sometimes they obviously cross over. And in trials, if we're in the civil jurisdiction, usually adjournments are only ever granted in exceptional circumstances. In court of protection, I find that judges are more inclined to do that because, of course, P can't speak for themselves, and it's more of an inquisitorial process. And it's absolutely right that the right decision is made rather than a tactical decision based on the evidence that's there at the time. And so you have, I think, more opportunities to seek adjournments if you need to, but that has to be balanced against the cost to P. Because, of course, in these cases, the general rule is that P will pay for the cost of litigation, subject to departure in Rule 19.5, of course. And it seemed to me that this case had rather protracted procedural history. The judge talked about there being 10 directions orders already in the case. So on balance, he pressed ahead with matters. One thing I think that was quite useful is that the court said that the court should not set the bar too high. And I think that's something that is sometimes forgotten with these cases, certainly by medical experts, I find. And I'm not trying to criticize them, but I think that's more born out of they're having to make quick decisions, usually about capacity in clinic. And they are obviously concerned about safeguarding and acting in P's medical best interests at the time, that sometimes when they move over to litigation, the bar can be set a little bit too high. And I find that sometimes experts will start from the position of P lacks capacity because they have a learning disability and the expert has to be disproven otherwise. And that's something I always look out for in an expert report. I'd encourage you to do the same, because that is a real indication or a red flag that the expert is reversing the burden of proof in a case like this. And with an individual like P who had learning disabilities, the judge emphasised that it's incumbent on a solicitor or any other professional to adjust their communication. So even though these might be quite difficult concepts that we're dealing with, we have to put it in a language that P can understand, rather than speaking to a client like me, for example, who, depending what day you catch me on, might be able to understand those concepts without it being broken down into more simplistic language. So the judge really drove home that when you are assessing capacity to execute an LPA, that you adapt your style as an experienced lawyer would do anyway. So here was the conclusion of Mr. Justice Paul. He concluded that P lacked capacity to execute the LPA. And he did so for these reasons. One, he had reservations about the expert's suitability to provide a report because he was an old age psychiatrist, but on balance accepted that the expert had sufficient level of qualification and experience. Whether that would have been the case had the expert been cross-examined, who knows. The second reason was that despite explanations by the expert when he carried out the assessment in 2019, P was unable to recall who his attorneys were what their authority was and what an LPA was. So in 2019, the nature and extent of P's impairments was such that he was unable to understand the most basic aspects of the LPA test. But of course, that only goes to 2019. So this comes to the next point, which is the court accepted the expert's view that P's learning disability and the presentation of it and its consequent impact on his ability to understand things was likely to have remained static. And so if it was static, then the court concluded that it will have been similar to 2019 and 2009. And in doing so, the judge effectively rejected the family's evidence. And I pause there to say what that evidence was. All the family members gave witness statements, and I think did go on to give oral evidence to say that P was able to make much more sophisticated decisions at the time. He was much more independent. They went to a cafe after he had been to the solicitors and said, I've just signed some important documents and it's so that mum can look after my money. But the court found that their evidence really went to a deterioration in P's behaviour rather than his ability or inability to understand. So that's why the court rejected their evidence. And in the round, the court said that the family's evidence of events surrounding the execution did not weigh heavily against the expert's view. So when balancing the various facets of the evidence, the balance came firmly down on the side of the expert. So it goes to show how important an expert report is in the context of an LPA challenge. And the court also said that P may have understood, that should say, that he was signing something important and it was to do with his money. But the evidence tends to show that P had no understanding of the scope of the powers, when they could be used, and the reasonably foreseeable consequences of not signing. The court didn't actually set out in its judgment what that evidence was. And that may have been for reasons of proportionality of the judgment. But what the court was there saying was, even though P was at the time able to acknowledge an LPA had been carried out, had an understanding of what it was, he was still unable to understand the scope of the power and what would have been the consequences of doing it or not doing it. The judge also alluded to this point, and I think this is quite important for those of you in non-contentious practice, is that the judge found that P wasn't the one initiating and instigating the process, and referred to him as being compliant with the process that was instigated by his mother. And you do often find this where family members aren't doing this maliciously or with ulterior motives, but they genuinely believe that their family member is able to execute a lasting power of attorney, and they genuinely want to safeguard their interests. So they organise the execution, so taking them solicitors, picking the solicitors. And I just flag up there that if you are a solicitor on the receiving end of that, you have to be extremely cautious of the family members being the ones driving that process. And that sometimes that can be seen as the family members trying to help, but actually it's a hindrance because it prevents or hinders you as a solicitor from properly assessing the donor's capacity at the time. Then the judge went on to criticise, as best as he could, the evidence that there were of JH's involvement. Now, the only piece of evidence it seems there was at the time was that JH had signed the certificate stating that he was an executive in a legal firm and that he was experienced in preparing lasting power of attorneys and assessing people's capacity. What the judge criticised him for, or felt that he couldn't accept that as demonstrating capacity sufficiently, was that he didn't make reference to P having a learning disability. Didn't make reference to P's impairment being a learning disability, and he didn't go on to say that he had experience of assessing individuals with a learning disability, which I have to say, I haven't come across yet a solicitor putting in an attendance note that they are experienced necessarily in assessing individuals with learning disabilities. Because I think if they felt that they were unable to do that, they would, as most solicitors I think would do, would be to go and get a report anyway. So the judge expected here to have, I think, some evidence, contemporaneous evidence of JH's experience and ability to assess P with this particular impairment rather than something that might be more common, such as dementia. And also there was no evidence from file notes or attendance notes or anything like that to demonstrate the explanations and discussions that took place between JH and P. So essentially, the court was left with a real absence of contemporaneous evidence of the execution of the LPA, save for the factual evidence provided by the family, which for the reasons I've given already was rejected. So in terms of those of you who are dealing with contentious applications, I think this is where this judgment's really quite helpful for our purposes. And the court gave some indication of the type of evidence it wants to see in these applications. So Mr. Justice Poole wanted to see evidence of the certificate provider's experience. Now, of course, there's no requirement to have a professional certificate provider. So this wouldn't necessarily apply if you had a lay individual carrying it out. But here, the judge said that, in particular, in making a sufficient assessment of the capacity of prospective donor who's known to have a learning disability or other impairment which might affect their capacity to execute an LPA, their usual practice or their specific recollections of making the LPA. So the judge wanted to know what type of work JH was doing, what expertise, so step qualifications, any other qualifications, which if I'm drafting proofs of evidence in my probate cases, I will always make sure that's in there anyway, because that forms a big part of their evidence. So I suppose those of you who are drafting these LPAs, it might be worth, if you particularly have a risky case, first of all, getting your own report anyway, but also just noting down these types of things. The second was evidence from the carers and the family members that was relevant to P's capacity to execute an LPA at the relevant time and to any changes in their condition relevant to capacity over time. What the court is obviously looking at here is direct factual evidence of the circumstances. And so this is where, as a solicitor dealing with proofs of evidence, you can have to guide your client and probe their ability to speak to P's capacity rather than their behaviour, because the two are very, very different issues. The third was about medical evidence. And I do tend to find that such reliance is placed by courts on the OPG report. And I have come across some OPG reports that do, I think, leave a lot of questions that are unanswered. And I do think, in my experience, the bar by some special visitors is put too high. So you're going to have to think how you challenge that if you are asserting that the LPA was valid. So think about your own medical evidence, other capacity assessments for around the key time, DWP assessments for benefits, because of course there is a section on there for cognition and capacity, records from carers, activity centres, anything that's likely to have a contemporaneous record of how P was presenting. Fourth, any assessment by a suitably qualified and experienced person of P's current capacity and reasoned opinion as to their capacity to execute the LPA at the relevant time. Such opinion being informed by review of relevant medical records, contemporaneous assessments, and the evidence of the carers and the family members. So picking the right expert, or making sure the OPG gets the right expert, and making sure that the expert has seen everything. I come across time and time again the special visitor having not seen all the notes and having not reviewed key factual evidence. And it just means that their report is predicated on a misunderstanding necessarily of the true evidential position. And the problem is, if you don't then get the expert to trial, then that you can't test it. And then if a judge is faced with lay evidence, but a report of an expert that's not going to be challenged, can see how it becomes easier for a very busy district judge to rely on the report. So lessons learned from this case, and these are my sort of key ones really. I think if you have an individual with dementia or any impairment with an LPA, because I think the scope of the test is actually quite broad and the number of things they've got to understand is quite extensive. And remember, most people don't know about the Mental Capacity Act, and they don't actually know about LPAs. They don't really realise what they actually entail. So I think sending out all that information, and I'm sure a lot of you do this anyway, but for those of you that don't, I think it is sensible to think about sending the information out in advance of the attendance, because then if you're bombarding a client with all that information in one go, even for a client who retains capacity, it can be very difficult for them to process all that information, which makes it more difficult for you to test their understanding. But also by sending it out in advance, you can test their attention as well. I think you've got to really think about getting your own expert evidence. And one point to bear in mind is some courts are reluctant to allow it because of the proportionality issues. But otherwise, the court's going to be faced with one expert report from the OPG, which may have some holes in it. So at the very least, you want to be making sure at the CEMC or the directions hearing that you have the opportunity to challenge that by way of questions. And I always, as long as the judge will let me, like to get the expert there. Because I have found that they can be challenged quite successfully when they give oral evidence, and sometimes not so successfully. So make sure once you've got the witness statements, there is provision at the very least to go back to the expert to point them in the direction of things in your evidence that demonstrates capacity. And with that goes to front loading at the DRH. So remember, the DRH is aimed at settling the matter, and there will be, I think, appropriate pressure from a district judge to bring the parties to some form of compromise, but sometimes it's not possible. So remember that you will go on after that to deal with directions. So think about things like what notes you need, so what third-party disclosure orders you need, because otherwise, if you don't do that, then it can become too late. You also need to think about the right type of expert. So for dementia, a psychiatrist would be appropriate. I personally think here, somebody like a neuropsychologist would have been better. In terms of non-contentious practice, there are a couple of points that I've already highlighted about noting your expertise on the file, which in a way seems a little bit, I suppose, insulting, I suppose. But if a court is saying in a judgment, it wants to know that factual piece of evidence, the risk is if that solicitor goes on or moves on and isn't available to give evidence at a trial, all you will have to rely on is the file. And so in the same way with probate cases, we need the attendance notes to be as detailed as possible. So too do these notes. I also think that, and I encourage individuals to do this, certainly with statutory will cases, is that when you do have an LPA or a will where you're thinking this is likely to be challenged at a later date, and we all know those cases when they come through the door where there's that real risk, is record in your note how you went about testing the capacity. I will never forget a trial I had a couple of years ago where a solicitor prepared the LPA, and the counsel for the OPG went through the test and said, did you do this? No. Did you do that? No. Did you do that? No. And there was no record of how that was tested, even though it was a really experienced solicitor with various step qualifications, solicitors for the elderly. And I think that part of the failing there was the omission to record how capacity was tested. And so I like to see, definitely in statutory will applications, and I think this should be reflected when you're preparing LPAs, is almost to do like a question and answer and record it there, because that's the, unless we get to a stage where we're recording attendances, that's the best way, or the best contemporaneous evidence of the contemporaneous capacity assessment. So those are just some of my key sort of tips arising from that case. It's definitely a case to go out and read yourself. If you are dealing with LPAs or contentious LPA challenges, then it's certainly a case that you need to be bringing to the attention of any district judge who's determining it. So that leads me to the end of the seminar. I hope that you enjoyed it. If you do have any questions, do feel free to email me at fcollinson@kingschambers.com, and I will endeavour to come back to you with those. But that just leaves me to say thank you very much for attending, and I hope to see you all soon.